A veteran New York judge has been appointed the special master to review documents seized from Mar-a-Lago. Raymond Dearie is a former federal prosecutor and served as a judge in federal court in Brooklyn. Both the Justice Department and former President Trump's legal team indicated they would be satisfied with his appointment. Trump asked for a third party to review the documents seized and remove any that might be protected by attorney-client privilege. The Justice Department is investigating Trump's handling of the classified documents. CBS News legal contributor Jessica Levinson joins me now for more. So, Jessica, what does this mean for the investigation, and what is Dearie actually going to do? What's his mandate?
So his mandate, and we'll wait for a little bit more guidance for Judge Cannon, but basically in her order from about a week and a half ago now saying, yes, President Trump, former President Trump, you can get a special master. Broadly, what Judge Dearie is going to look at is exactly what you said. Are there any documents in the documents that the FBI took from Mar-a-Lago that are covered by attorney-client privilege and cannot be used by the DOJ investigation team? Separately, are there any documents that are potentially covered by executive privilege, which potentially could not be used by the DOJ investigation team? Now, the executive privilege claim is a really strange one in this case, as I think you and I have talked about, because it's a former president asserting a claim of executive privilege over documents against the executive branch, against use by the Department of Justice, in a situation where the current president has said, I'm waiving executive privilege, and the documents are being used in a criminal investigation. Executive privilege is a limited privilege. It's not an absolute privilege. And we know that one of the limitations is unless you need the documents for a criminal investigation. All of that is a very long way of saying, I think it's going to be a little bit murky for the judge to look through and see which documents are potentially covered by executive privilege. But that's basically the mandate, to look into those two buckets.
So that second bucket, the sticky one you're talking about, the executive privilege claim, is this, as we puzzle this out loud here, as this just happened, is it, because you could imagine making one claim about a former president's ability to assert executive privilege and whether that exists at all, no matter the quality or quantity of documents. Another, you could imagine going document by document on this executive privilege claim, not the attorney-client one, but what's your sense of that? Do you think it's a document by document question, or kind of one that goes over the whole scope of whether a former president can assert this privilege?
I think the way you ask that question is so dead on, because the threshold issue really is, can there be any claim of executive privilege here? And frankly, as a legal matter, no, there cannot be. But Judge Cannon, who has not rescinded her order, has not yet reconsidered her order, has said maybe there can be. And therefore, because you've passed that threshold, then I think it has to be exactly what you asked about next, which is document by document. There's a whole host of documents in this tranche that was found at Mar-a-Lago that could in no circumstance, even if executive privilege applies, could in no chance be covered by executive privilege. So I think there's going to be this one pile, potentially covered by executive privilege, another pile potentially covered by attorney-client privilege. And then we're going to have another conversation about whether or not the privilege would apply at all. And it looks like from some activity on the docket that the DOJ may be appealing that issue to the 11th Circuit. So all of this is complicated by, will Judge Cannon reconsider her decision that executive privilege could apply? And will the DOJ, if she doesn't, decide to appeal that up to the 11th Circuit?
Right. And so then if they appeal, that would, they'd be asking the 11th Circuit to basically make this question of assigning the issue of executive privilege to a special master. They would say that can't be done at all and be done with it. That's essentially what they'd be asking for?
So I think so. And I hate to give you this it depends answer, but
Sure.
When it comes to Judge Cannon's ruling, it depends how much of it they decide to appeal. We know in their motion for reconsideration, they didn't ask her to overturn everything. They basically said, you can't pause the Department of Justice from helping the national security community when it comes to their investigation. And then folded into that was this idea that executive privilege doesn't apply that you and I have been talking about. If and when they appeal to 11th Circuit, I think they would go ahead and say, I want to remind you, there's no world in which executive privilege can apply. You want a special master? That's fine, but it only considers whether or not there's attorney-client privilege.
All right, Jessica, we're going to be talking about this a few more times. Thank you so much for sprinting out and helping us put this together on the fly here. Really appreciate it.
Oh, of course. Thank you.